Thank you, everyone. Please be seated. We are here this morning for 3 cases. The first one is State of Iowa versus Blahnik Church. That is hereby submitted without oral argument. We'll begin our oral arguments today with Senator Roby Smith and others versus the Iowa District Court for Polk County. It looks like the parties are ready to proceed. And Mr. Wessan, it's my understanding you'll be arguing? Yes. Thank you. You may begin.
May it please the court. My name is Eric Wessan, and I rise today representing the certiorari plaintiffs in this case. The certiorari plaintiffs are a group of 11 current and former legislators who share the fact that they voted for 2 election integrity bills a couple years ago. LULAC has sued the state over enforcement of those bills and has issued subpoenas to these 11 non-party legislators, seeking all communications between the legislators and individuals outside of the legislature. The legislators moved to quash those subpoenas at the district court, and that motion was denied. Before the court, there are 3 primary questions today. First is whether these materials are subject to legislative privilege at all, which the district court found. Second is what is the scope of legislative privilege and whether that privilege is an absolute privilege. And third, if this court agrees with the district court that the privilege instead is a qualified privilege, whether that privilege should be abrogated. To start, after briefing was submitted, 2 recent circuit court cases aid in understanding the history and tradition of the common law legislative privilege in a way that this court should find persuasive. One, the In re North Dakota Assembly case came out of the 8th Circuit and issued a writ of mandamus ordering the district court below to quash subpoenas issued to legislators there. And the other, the Pueblita case out of the 5th Circuit, found that there was a qualified privilege and found that there was an abuse of discretion declining to abrogate that privilege. While those 2 cases take a slightly different approach in how they describe the privilege in question, in function, the 2 tests that those courts use are very similar. First, they identify whether the legislative privilege applied to materials, in both of those cases, communications between legislators and non-legislators, and they found that they did. And then second, they asked whether there were extraordinary circumstances that warranted abrogating that privilege in order to produce those documents. Whether this court chooses to find that there is an absolute privilege or a qualified privilege, in neither instance should that privilege be abrogated here today.
What would be the textual basis for finding an absolute privilege in this case?
That is so the best textual argument goes to the Constitution and Article 1, Section 20, which this court has not interpreted in that context. The stronger argument probably is an atextual one, going back to the origins of the common law legislative privilege beginning in 1399. This court has held multiple times that at the time of the state's founding, the common law was incorporated into the background principles through which it assessed laws, privileges, and immunities. And so what the state is now asking is that this court look at the common law privilege, which has been inherited from England through the states, has been incorporated in some states and in the federal government in the free speech and debate clause for the legislators, but in many states has not yet been incorporated in such a textual manner.
We do with the fact that the Iowa Constitution does not have a speech and debate clause.
So one place to look would be the 1979 Iowa Attorney General's opinion, which noted that Iowa is one of 7 states that does not have a speech and debate clause in its constitution. But each of those states in its jurisprudence have acknowledged the historic common law tradition recognizing some form of a legislative privilege.
Right, but to Justice McDonald's argument, how does that weigh in whether or not we should recognize an absolute privilege?
The scope of the privilege is as unaffected by the lack of a later enactment in the Constitution as it would be if such a similar enactment had been made. So the scope of the privilege is unaffected unless at some point either the legislature were to choose to pass a law overriding that common law tradition, or the people of Iowa were to pass a constitutional amendment adjusting the scope of that privilege. Because
Other courts have recognized an absolute privilege in a jurisdiction that lacks a speech and debate clause.
prudence on that is fuzzy. Oftentimes, even when jurisdiction recognizes an absolute privilege when it comes to these immunities and legislative privilege, they describe some exceptions. So in full candor, the absolute privilege, such that it would extend, for example, to evading a federal criminal charge, is not frequently found. That being said, states have, especially recently, found that that privilege is extremely difficult to abrogate. So whether it's the Edwards against Wessan case, which within that case refers back to an earlier Virginia case relying solely on the common law and not its privilege, its free speech or debate clause, or going to the Sixth Circuit Kent case, which tracks the scope of the common law legislative privilege over time. In either instance, you have fairly robust protection for legislative materials and communications.
So is your argument that this is a common law rule with kind of constitutional dimensions, or that it's a constitutional rule, it's inherent in the separation of powers? It seems like that might make a difference in how we view this.
The court could take either approach. The common law tradition is not constitutional in its character. I believe that the legislature could, if it chose, affect or modify the scope of that privilege through legislative enactment, and it would not directly violate the Iowa Constitution to do so. That being said, there is a strong separation of powers argument that goes back to this court's holdings in Teague against Mosley, or in the Dwyer case, that respect the importance of the ability of constituents and individuals to communicate with legislators in the legitimate sphere of legislative activity, and understanding the respect between the coordinate branches and the lack of a will to substantially intrude in the legislative process would certainly inform this court's later decision on how to adjust a law that would affect the speech and debate clause.
That's right. Let's say the General Assembly could change or modify the common law rule by House rule. So, like, for example, in Dwyer, they had the rule about not sharing the phone number information. If that's right, does the legislature's silence in this situation have any import? I mean, they could pass a House rule that says any documents legislators receive shall be privileged and shall be not subject to disclosure, but that hasn't happened here.
Failure to act, given the existing long-standing common law tradition, as well as this court's jurisprudence, should not be read as unwillingness to ensure that those materials are protected. If this court were to issue a ruling adverse to the legislature, it would materially affect the way that they are able to interact with individuals, with experts in their information-seeking role in order to craft legislation. And while the legislature, after the fact, could act in a way to try to modify this court's holding, the simplest path forward is to follow the recommendations, the persuasive authority from these recent circuit court decisions in the Fifth and Eighth Circuits in order to ensure that the privilege of those seeking to communicate in a free and robust way with their legislators is protected.
Sought in these subpoenas relevant to our analysis of the constitutionality of these, what you call voter integrity laws?
The simple answer is no. There is some dispute as to the proper standard of review as to count 4, which is an allegation of viewpoint discrimination in an election law context. At my best search, I could not find an election law case that found viewpoint discrimination justified strict scrutiny in this manner. This court has held recently and going back more than 100 years that the views of individual legislators is not important for determining what the actual text says. And a recent case.
I mean, it seems to me, I do agree that I actually think both of you kind of are wrong about the standard of review here. It's not rational basis, but it's also not some kind of strict scrutiny where an intent to benefit one political party really establishes anything that's meaningful in the case. Isn't the test really kind of the verdict test, the Crawford test, whether there's a substantial burden in the way of voters? We look at the burden. We don't care what the legislature intended if the legislation is neutral on its face. Isn't that the standard?
With you that there is no need to look at the intent of the legislators. The state's position is that for each of the claims in this case, that rational basis is the correct test. But even if this court were to find as an issue, which I don't think it needs to reach.
Rational basis in the other Lulak case about 3 years ago, did we?
I do not believe so. But there are different claims in this case and in that case, and I think it's important to look at the substance of the claims that are being brought here under the Iowa Constitution. But regardless of the standard of review, the Brnovich case listed a series of materials that could be helpful in determining whether in that racial discrimination case, the legislature acted in a way that was inappropriate or included invidious discrimination. That didn't include private communications between legislators and third parties. Or in a later case, a Mi Familia case out of the District of Arizona, that court relied on the Fifth and Eighth Circuits to find that there were other ways to look at the law and determine whether or not there was invidious discrimination such that it didn't need to abrogate the legislative privilege. And those included whether the legislature had a history of discrimination, whether they changed from their standard procedure in order to pass the law. There were a series of factors there that helped aid it in determining, even though it found that there was a qualified privilege, that it need not be abrogated. Lulak tries to wave away a different Arizona case, the Puente, Arizona case, which uses the history of the absolute state immunity from suit as a way to explain why it found an absolute legislative privilege. That case preceded and foreshadowed what was going to come from the Fifth and the Eighth Circuits, in which those courts, looking at the legislative privilege, found that absent extraordinary circumstances or an extraordinary federal interest, that the legislative privilege should not be abrogated. If the court has no further questions, I'm happy to take a seat.
I do, actually. An argument you make in your brief, and you just touched upon now, of the lack of a federal interest here, which kind of animates all the federal case law that the district court relied on. Does that make a difference here if these are state constitutional claims? Or is there something unique about the federal interest that would justify a qualified privilege for federal claims that wouldn't justify a state constitutional claim?
The federal courts seem particularly solicitous of their intrusion into the state process, and so their analysis focuses on the different roles of the states and their desire not to unduly impose their view. So here, when it comes to the state court reviewing a state constitutional claim, it seems that the best analog would be to look at how the federal courts apply the common law privilege to federal claims. That would seem to be the closest analog. And in those cases, it is far closer to the absolute privilege.
Federal legislators.
Yes, the federal court's treatment of federal legislators is likely closer to how the state courts should deal with state legislators necessarily than the way federal courts deal with state legislators, because the commitments between the branches is closer there than it is when you're dealing with the difference between the federal and state courts.
Tend to be more on the absolute side of the nature of the privilege. Okay.
Thank you.
Mr. Fox.
Good morning, Your Honors, and may it please the court. I'm David Fox on behalf of LULAC of Iowa. The legislators ask this court to grant them an absolute privilege from lawful discovery requests that appears nowhere in the Iowa Constitution or the Iowa Code. The court should decline that request and affirm the district court's order. I plan to focus on 3 points today. First, the legislators' waiver of the express statutory official confidence privilege that ought to be what governs this dispute. Second, the problems with the legislators' argument for an absolute privilege. And third, the district court's reasonable and correct application of a qualified privilege. First, the official confidence privilege. Iowa has a statutory privilege that covers exactly the sort of documents at issue here: communications made to a public officer in official confidence. That's Iowa Code 622.11. But that privilege is waivable, as this court has held, and the legislators waived it when they did not invoke it below. Moreover, that privilege is qualified and subject to a balancing test.
I just want to make sure that I understand your argument. Is your argument that communications with third parties is within this privilege, but it has been waived, or that communications with third parties are not part of the privilege at all?
This official confidence privilege, Your Honor, our argument is that they would be subject to analysis under that privilege. Again, it's a qualified privilege that's subject to a balancing test, but that it has been waived. And essentially what the legislators are asking this court to do is invent a new doctrine of Iowa law that the court has never weighed in on before to save them from their waiver of an expressly applicable statutory privilege. And it would be anomalous for the court to adopt an absolute privilege in particular in that context, where the governing statute provides for a qualified privilege. Second, the absolute privilege. Nothing in Iowa law supports an absolute legislative privilege. If the legislators would like an absolute legislative privilege, they should enact one by statute. The Iowa Constitution does not have a speech and debate clause, which is the clause in the federal Constitution and nearly all state constitutions on which invocations of absolute legislative privilege have been based. The drafters of the Iowa Constitution could have included one. They included a lot of clauses from the federal Constitution. They did not include that clause. Moreover, it is the speech and debate clause on which federal courts' absolute privilege for federal legislators is based. So the state's argument just now that that is the most analogous basis for privilege here ignores that that privilege in federal court is based entirely on the speech and debate clause, and there is no speech and debate clause here. Beyond that, I heard the state to
The argument that the privilege is just inherent in the nature of divided government, that it's pre-constitutional, it's common law, and that it's been recognized universally in the United States.
common law cases going back to England are really concerned with legislative immunity rather than privilege. And that makes sense because there really was not discovery in the old common law courts at all. So this issue would not have come up as a matter of discovery as distinct from immunity. I think certainly the idea that legislators should have some protection from civil liability for their legislative acts is inherent in the legislative role. We're not arguing that they should be liable for legislative acts. But the federal courts that have looked at this in detail have not held that absolute immunity from lawful discovery requests is inherent in being a legislator. And
Story wrote that he thought it was, because if you subjected a legislator to the subpoena power, to enforce it, ultimately you would have to arrest that legislator for refusal to comply. And he thought that was a significant problem with subpoenaing legislators.
Two things about that. First of all, I think that is a very speculative problem. I think there's no reason to believe that legislators would ignore a lawful discovery order, and to say that the court would have to arrest them if they did ignore an order is, to me, a very surprising assumption to make about the way legislators would respond.
Let's assume that the court was right and that there was an order for the legislator to produce documents, and they said no. We're not going to produce the documents, and we're not going to be deposed about whether we read them and what we thought of them and how those were relevant to our deliberations on a vote. Then what?
First of all, I have every confidence that if there's a court order that has been finally appealed that orders the legislators to produce documents, that they will respect that court order. But if they don't, as Your Honor has asked, that at that point is an action outside of the scope of their legislative activities. It's not as if they're being subjected to liability for a vote in the legislature or something they said in the legislature. They're being...
District court held them in contempt. 664. Do you think it's a problem if the district court then said, I'm going to fine you or incarcerate you for up to 6 months as allowed by statute because you refuse to discuss how these documents were relevant in your decision to cast a vote on a piece of legislation?
No, I do not, Your Honor, because the decision not to produce documents in response to a court order happens outside of the legislative sphere. It's no different than if they were arrested for speeding on their way to the legislature. It is outside of their actual deliberation and actions within the legislature. They will have decided to violate a court order that doesn't relate specifically to how they're voting or how they're debating in the legislature. So I think they're subjected to liability, yes, but for something that is not a purely legislative act.
Even if it was, let's say they were deposed, and the question is tell me about your calculus. Why did you vote in favor of this legislation? And the legislator says, I refuse to talk about that. I believe that's privileged. That's my deliberative process. Can a legislator be incarcerated for refusing to discuss that thought process?
That, Your Honor. First of all, that issue will not arise in this case because the district court was clear in this case that it was only ordering the production of information communicated with third parties. And so the internal reasoning of how someone voted will not come up. It would not be subject to this order. If a
documents relevant. So let's take an example. The subpoena asks for documents from the American Legislative Exchange Council. Let's assume a legislator received a report from ALEC. What does that demonstrate that's relevant to your case?
May reveal, Your Honor, the information that was requested and considered by the legislature in connection with enacting these bills. And if I could give you an example, in the Fourth Circuit decision of NAACP versus McCrory, one of the key pieces of evidence found, that was a race discrimination case. One of the key pieces of evidence on which that decision turned was that legislators had requested and received data about the ways in which racial groups voted. Not like for whom, but what manner. Who registered early, who used early voting, when did they use early voting. And they had requested and received data on how various racial groups voted, and then they went on to enact a bill that specifically targeted the manners of voting.
Aren't those claims totally different? You have the 14th Amendment, you have Section 2 of the Voting Rights Act, you had maybe back then Section 5 as well. I mean, those claims are totally different from a claim that a neutral voting regulation was enacted by the majority party for the benefit of the majority party. I mean, you could probably go to Illinois and pursue the same claim against the other party for voting laws over there. I mean, has such a claim ever been recognized?
To be clear, is that this is not a neutral voting law. That these are voting laws that specifically target the means of voting for one political group.
That's an argument. On its face, the law is neutral. You would have to agree with that. I mean, shortening the hours of voting shortens them for everyone, whether you're a Republican or a Democrat, right?
Certainly that's true, Your Honor. The law is facially neutral. It does not facially discriminate against a named political group, but it surgically targets for restrictions, the particular ways in which members of one political party disproportionately vote. And our position in count 4 of our complaint is that that is a standalone violation of Iowa law. And so this is discovery that we believe is directly relevant to that claim. The court doesn't have the ultimate viability of that claim in front of it. It hasn't been thoroughly briefed. There was no motion to dismiss. That question is not here. The question is relevance.
It's part of the qualified privilege inquiry. If we agree with you there's no absolute privilege, then shouldn't we then be considering what's the relevance to any claim that realistically could go forward in this case?
That is a relevant part of the qualified privilege analysis, and the district court did consider that here, but it needs to be viewed through both the abuse of discretion standard and the relatively liberal discovery standard, which is to say we don't need to prove to you that this will absolutely, certainly help to support our claims. We don't know what we will get in response to our subpoenas. The question is, in essence, is it reasonably calculated to lead to evidence that will support our claims? And I would...
You count 4, what are the elements of that claim that this material would be relevant to?
It would be relevant to showing, Your Honor, that these laws were adopted specifically because these are means of voting that are used by one political group.
Sorry, I'll just finish up. What authority supports that is relevant with respect to outside of the racial context, where you've got a suspect class, and now you're just talking about political party?
So, Your Honor, I'm not aware of a directly analogous case. This is an Iowa constitutional case. I don't believe this court has addressed a directly analogous case. But there are 2 strains of constitutional law that we believe support this claim, the fundamental rights strain and then the viewpoint discrimination strain. So under fundamental rights, it's well established in Iowa that voting is a fundamental right, and discrimination on the basis of fundamental rights is generally subject to strict scrutiny.
Court relied on, but we've applied the Anderson-Burdick test. Why should that test not be what we apply in this case?
Under the Anderson-Burdick approach, the standard of review depends on both the level of burden that the law imposes and on the reasons for that burden. The way the U.S. Supreme Court has phrased it is that a neutral and not unreasonably burdensome law is subject to a relatively lower standard of review. And our position is this is not a neutral law.
First, right?
It has to consider both at the level of deciding the standard of review. And one point I would like to emphasize is that it would be anomalous to rely on the standard of review here in denying these discovery requests because the discovery we get may affect the standard of review. One of the things the court said in AFSCME in explaining why it was a rational basis case is that there was no evidence that these laws were passed to target people because of their political views. Well, that's the sort of evidence we're looking for here. And so our discovery may affect the standard of review ultimately in this case.
The relevance question, and I'm really struggling with what the documents would show. So let's say an incoming document from a lobbyist, ALEC, whatever, that's sent to a legislator. What does that establish in support of the claim without additional information of how the legislator viewed or considered the information received?
Acknowledge, Your Honor, that this determining the motivation behind legislation is going to be an inherently difficult task. The way the U.S. Supreme Court approaches it is under the Arlington Heights analysis, which says that you should consider all direct and circumstantial evidence that's available and might shed light on the legislator's purpose. And that's what we think the court would do in this circumstance as well. And so the evidence they received, if they then went on to pass a law that restricted voting in exactly the areas on which a disfavored political group used to vote, then we think that would be strong circumstantial evidence that that was their motivation. We're not saying it would be dispositive necessarily. We would ask the court to consider all evidence.
Testimony from the legislator. So just the fact of receipt is sufficient to support the claim that the legislation was passed with some sort of unlawful purpose.
We're not saying that it's sufficient for us to win on the merits. What we're saying is that it's relevant and highly relevant. That yes, if they received data suggesting that exactly the ways in which a disfavored party voted, and then they went on to restrict exactly those ways, I think that would be strong circumstantial evidence. Whether it would be dispositive or not, I think it depends on the other evidence. Certainly we'd rather have direct testimony, but we recognize that there are concerns about direct testimony of legislative purpose, and that's what the Supreme Court said in Arlington Heights as well. And so the court has to do the best it can, which is to look at all available direct and circumstantial evidence. I want to talk briefly about the two recent Federal Court of Appeals decisions from the Fifth and the Eighth Circuit. As I understand opposing counsel's position, and I agree with this, both of them do ultimately adopt a qualified privilege. They do not adopt a absolute privilege. That's very clear from the Fifth Circuit. The Eighth Circuit decision is a little less clear on that, but it ultimately acknowledges that in some cases the privilege might be overcome, which is the hallmark of a qualified rather than an absolute privilege. The question then is, what is the standard for the qualified privilege? And I don't read either of those two cases to really have a clear standard. They clearly, especially the Eighth Circuit, clearly did not like the five-factor test in the federalism context of a federal court and a state legislature. But that five-factor test that was applied here worked well for decades in the federal district courts. And as I believe the state has conceded, the context of a federal court subpoenaing a state legislature is actually more sensitive and not less sensitive than the context of a state court subpoenaing a state legislature. I see my time has expired.
On that. So as I read the federal cases, when you're dealing with kind of federal court, federal legislator, the privilege tends to be much stronger, actually. Now, whether that's textual, whatever. But at least there's some indication that when you're dealing with kind of these horizontal actors that are supposed to be equal within their own systems of government, that there is a stronger privilege. But so what is your response to that? You seem to say no.
The federal decisions from the Supreme Court are clear that the reason there is an absolute legislative privilege for congresspeople is because of the speech and debate clause. And the speech and debate clause at the federal level does not apply to subpoenas of state legislatures. So that's why it is a textual matter. The idea that supremacy for federal law is a distinction here doesn't make sense because the Iowa Constitution, too, is supreme over contrary Iowa laws. It's express about that. And these are constitutional claims. So I do think, it's inherent in the horizontal separation of powers that the branches will butt up against each other to some extent. And certainly the branches try to be respectful of that, but it is less inherent that the federal government will be interfering in state sovereign activities. Thank you, Your Honors.
Thank you. Given that I spent most of the time on our principal argument on the absolute privilege, I want to touch on two of the other points that opposing counsel raised concerning the scope of legislative privilege. The first deals with the idea of the privilege being qualified. And certainly, while there seems to be some agreement that the privilege is not absolutely absolute in both the Eighth and the Fifth Circuit, they acknowledge the Supreme Court has been willing to abrogate that privilege in the context of a federal criminal prosecution. In the Eighth Circuit, they were clear that when it comes to civil claims, that the privilege itself is close to absolute. And while there is no extraordinary circumstance here, to the extent this court finds a standard challenge to an election law to be so extraordinary, that would likely bring with it the ability for future litigants to subpoena legislators in all sorts of constitutional claims. When someone brings a constitutional claim, that is likely very important to them. And allowing someone, because of the relevance of the potential intent, to seek discovery from legislators as to their process in any claim involving constitutional concerns would raise serious questions.
What is your response to opposing counsel's point that if the most analogous cases are the federal cases involving the courts and Congress, and the fact that those cases rely on the speech and debate clause, whereas Iowa does not have a speech and debate clause? What's your response to that argument?
Both the Eighth and the Fifth Circuit address that point. They go back and look at the traditional way in which the legislative immunity, which has been explicitly considered for state legislators as well as federal legislators, has been extended over time. I think the Fifth Circuit said that it saw in the distance the possibility of the immunity and privilege analyses separating, but but it needn't reach the horizon in that election law-related case. So while the common law roots of the protections for legislators from discovery have a explicit textual hook in the federal context, that does not mean that the lack of textual hook eliminates this fundamental background principle establishing the state legislator's ability to engage in the legislative sphere.
Let's just say for the sake of argument that it's not absolute. Let's just say for the sake of argument that the court's going to apply that 5-part test. Would you agree with me that the most difficult one that seems to be, or the one that's common that we're discussing is relevance? And if so, help me. I know Justice McDonald's asked about it. I think everybody's asked about it. Now I want you to answer it for me. Help me understand better the relevance of the request.
First, I would say that the 5-factor test here in the briefing was cited to in Benesek against Lamone, a federal district court case out of Maryland. The Maryland Supreme Court, in its 2022 redistricting legislation, decided that it would not use that test. It recognized, one, that the Benesek case was later vacated by the Supreme Court, and two, that the 5 factors were an inappropriate lens. But
Let's use it. And help me understand, why do you believe it's irrelevant? This is the one prong that I'm looking at right now.
so assuming that this test is going to be used, the relevance factor should weigh against disclosure, because regardless of what these 11 legislators have received from third parties or constituents, those documents don't bear on what the actual facially neutral law says. And so to the extent that people, solicited or not, sent their thoughts and ideas concerning the proper scope of election laws in the state of Iowa to those legislators, their opinions don't bear on this court's analysis as to whether or not those laws are lawful.
Those communications provided evidence about targeting, so that, to your point, to your opposing counsel's argument, that if there was communications that said this is how Democrats vote, these are the modes that they use, and so let's limit those as much as we can to get at Democratic voters. Is that relevant to their viewpoint discrimination claim? And if not, why not?
It's not clear that a viewpoint discrimination claim is cognizable in the context of challenging an election law. As other questions from this court recognize, this would be a new foray into challenging.
Need to decide that now on this discovery? My concern is that, are we deciding the underlying claims by deciding what discovery is available?
Has elapsed, but if I can answer the question, I would say first, the simplest way would be to find an absolute privilege in the civil context, in which case that wouldn't be necessary. To the extent that this court decides to find a qualified privilege, if it adopted the test used in the 8th or the 5th Circuit, requiring extraordinary circumstances to abrogate the privilege, it also would not be necessary to reach that later question. If instead it adopts the test, the 5-factor test resisted by the Maryland Supreme Court, and got to relevance, to the extent that it did not find that relevance factor dispositive and found that the other factors weighed against abrogation, it also would not need to reach that issue.
Could you address the statutory privilege or confidentiality for with third parties, and was that waived, and how does it apply to our analysis? The 622.11.
It's an interesting question as to the 622.11 waiver. Oftentimes, the arguments made about waiver in terms of this type of privilege concern the fact that the legislators were communicating with third parties at all. Those claims, after the 5th Circuit and 8th Circuit decisions, seem to be fairly foreclosed after an analysis of the traditional scope of the legislative sphere and the legislative process. As far as 622.11, as LULAC noted, that type of privilege needs to be asserted and asserted by the state. There are different factors, including that the communications in question be made in confidence. There hasn't been a case dealing with the application of that statute in the context of legislators at all. Most of those cases tend to deal with prison or law enforcement officials testifying. To the extent that this court were to find that that privilege applied, there certainly has been no affirmative waiver. And some of the cases cited to in the briefing do discuss waiver and legislators implicitly waiving those claims. Those frequently come from suits brought by the legislators themselves. This is not a suit in which the legislators are a party, and the legislators did not affirmatively waive that.
You speak to the chilling effect that if we were to allow these subpoenas to be enforced, how would that impede legislators' ability to do their job, and why is privacy important when talking with constituents?
Of this court should be looking at the Dwyer case that talked about the free and fair communications between constituents and their legislators being of fundamental importance to the legislative process. Ultimately, future litigants could engage in fishing expeditions, and if they were to challenge the constitutionality of a law, they could send subpoenas, depending on the way this opinion is written, to all legislators who voted for it, perhaps those who voted against it. There are lots of very foreseeable, what would not be unforeseen consequences of the way the legislature would have to reform its approach to legislating in order to accommodate an adverse decision.
Go ahead.
To your answer, but so one of my primary concerns is testimony of legislators about their mental process and how to cast a vote. And I asked that question to Mr. Fox, and his response is, well, maybe that wouldn't be necessary, in that the mere fact of receipt of certain documents might create an inference of some sort of unlawful intent. And I think you could picture that. Maybe if some organization sent a document to all the legislators that said, if you're interested in suppressing XYZ voter base or turnout, here's the kinds of laws you should craft. Maybe that would create some sort of weak inference. Maybe even at the discovery stage, it's arguably relevant or would lead to discovery of admissible evidence. What is your response to Mr. Fox's argument on that point?
That this court takes seriously the idea of a legislative privilege. I think it was the Eighth Circuit in its decision that described this type of subpoena as an assault on that privilege. Even if there's some possibility that something admissible or relevant might turn up, and again, I'm not sure that any document that could turn up would actually be relevant to the claims here, nor that relevance should be a factor in this court's decision, even if it finds that the privilege is qualified. But putting those aside, if this court were to find, or if the district court were to find some potential evidence, the weight of the legislator's interest in secure communications with their constituents, with experts, with people who have an interest in the law should weigh heavily as well. This isn't a standard question of admissibility. This implicates the actual rights of the legislators and the sanctity of the legislative process. Thank you.
The Senator Roby Smith and others versus the Iowa District Court for Polk County is hereby submitted.